Good afternoon, welcome. The name of this panel is Intellectual Property the Root of All Evil? And our speaker today is Dean Baker from the Center for Economic and Policy Research. I would like to give the floor to Dean.
Oh, thank you. I'm going to go on my usual tirade about intellectual property. This is something I've been doing in my spare time for about close to a quarter century. I'm primarily a macroeconomist, so I write about things like recessions, inflation, housing bubbles, and unemployment and the like. But I've been fascinated by intellectual property and its importance to the economy, which has certainly grown enormously over that period. In part because I think that most economists don't have much appreciation of them. And certainly most people outside of economics, they don't understand its importance. And, you know, again, I think it's enormously important, and I sort of wish I had more time to work on it, but I do what I can. So let me give you my slideshow, and there we go. Sure, I'm in the right spot. Okay, and give you the basic story. The four main points: first off, that intellectual property is a policy decision. It's not a fact of nature. To my mind, that's kind of obvious, but you have a lot of discussion of it that treats patent, copyrights, other forms of intellectual property as though they're just given to us, that's the world, and what can you do about it? They're there, live with it, whatever. And the point I want to make front and center, no, it's a policy choice. Obviously, it serves a purpose. We could argue whether it's good or bad, should be stronger or weaker, but it's a policy. It's just like tax policy. It's just like any other policy. It's a policy. We decide what it is. It's not given to us. Secondly, there's real money at stake. You know, in Washington, you often have big arguments over small sums of money. This is big sums of money, and there's no discussion. And again, it's kind of mind-boggling to me that there's so little appreciation of how important intellectual property is to the economy, to the distribution of income. It largely goes unnoticed. And throwing out the 1 trillion figure, that's probably a conservative estimate. But when I'm saying 1 trillion, that's what I would call the rents associated with patents, copyrights, other forms of intellectual property, trademarks, other forms. And that's probably a very conservative estimate. I'll give you sort of briefly how I get that, but again, you know, it's almost certainly very conservative. The third one is that it has redistributed large amounts of income upward. So many people, myself included, are very concerned about the upward redistribution that we've seen over the last 40 years in the United States, the rest of the world as well, but certainly in the United States. And intellectual property is a big part of that. And Bill Gates is my poster child. He's one of the richest people in the world. I guess he's not the richest anymore, but he did have that claim at one time. I like to say Bill Gates would still be working for a living if the government didn't give him patent and copyright monopolies on Microsoft software. I've been saying that, and people point out to me, well, Bill Gates is 70, and I go, okay, he'd probably be getting Social Security now. But in any case, he would not be one of the richest people in the world if it were not for intellectual property. And the last point, there's alternative mechanisms for supporting innovation and creative work. So I'll just outline those. Obviously, I don't have time to go in great detail about how those would work, what they would be. Point just being, intellectual property, patents, and copyrights are one way to support innovation and creative work. They aren't necessarily the best way, and they're certainly not the only way. That's simply a factual matter. Okay. First point, intellectual property is a policy to promote innovation. I don't know how many times I've started talking about patents and copyrights, and I get people start yelling at me, it's in the Constitution, what can you do about it? And go, yeah, it's in the Constitution. It's a power of Congress. It's not in the Bill of Rights. It's not like a right to freedom of speech, freedom of religion, whatever. It's a power of Congress. Article 1, Section 8. And it lists the powers of Congress. So it's like the power to tax, the power to declare war. If Congress doesn't tax, does anyone have a cause of action because Congress has to tax? Of course, that's absurd. So if we didn't have copyright, didn't have patent, well, you can point to, well, Congress could have copyrights, they could have patents, they don't have to. And the wording of the clause where you have the basis for copyrights and patents, it's very clear that to promote the progress of science and useful arts, that's verbatim. That's what the Constitution says. So it's very clear in writing the Constitution, it was very well understood that this is a policy that Congress could use to promote innovation and creative work. So it's not as though there's any requirement to have it. Again, once you have a copyright, I think it's reasonable to say that should be treated as property. You don't just ignore it. You know, that's property. I think that's reasonable. I'm sure that's what courts have ruled. But the decision to have it or not, that's up to Congress. That's a policy decision, not a question of individual rights. It's not like our right to freedom of speech. And just to give some of the issues that come up, and these literally come up all the time, the length of the monopolies. So copyright in particular, it used to be 26 years if you go back far enough. And we've been extending it over the last half century. It was 50 years till, I think it was 76 when they had the first major round of extension. So it was 50 years, then they made it 75 years, and then they made it 95 years. And incredibly, at least to my mind, incredibly, when they had these extensions, they made it retroactive, which my reason for saying it's incredible is we could say a long copyright will give people more incentive to do creative work, write a book, a song, a movie, whatever it might be, but you can't give incentive to what people might have done 75 years ago or 95 years ago. And the joke, and it's not really a joke, it's actually true. One of the main motivations here is that Mickey Mouse was literally going to run out of copyright, that the period of Mickey Mouse's copyright was hitting up against a border when they extended it to 75 years. And then again, when they extended it to 95 years, and Disney wanted to extend it each time. And they succeeded. They didn't get extended again. They wanted to extend it from 95 years to 115. Congress didn't go for whatever reason. I don't know the specifics of who was opposing it. But in any case, it's sometimes referred to as the Disney Copyright Act. But anyhow, so you could make it longer. We did that with patents too. They used to be 14 years. Well, they were different for different types of items. We made them now 20 years from the date of application. So again, the length of a patent, copyright monopoly, entirely a matter of policy. It's not like God gave it to us. Secondly, what's covered? Well, we've extended the coverage of patents. You know, could patent life forms, business methods, softwares. The extent of patent coverage constantly is being tested. I just mentioned a couple of the sort of famous cases, which, you know, to my mind were pretty absurd. Apple sued Microsoft when Microsoft came out with Windows, saying that it violated their copyright. And what they were saying was that it had the same touch and feel. I'm sorry, it wasn't copyright, it was business methods, touch and feel as the Apple computer. So therefore, it was violating their copyright, or I guess it would have been patent on business methods. Amazon did the same thing with one-click shopping. They said that, oh, we have a monopoly on one-click shopping. So anyone that we have a patent on one-click shopping, anyone who wants to have one-click shopping on the web, these are obviously early days of the web, they have to pay us for that. The courts threw that out. They give them a more narrow patent. But in any case, both these they lost. But, you know, again, this is, you know, well, at least you had companies with lots of money, paid lawyers who commanded big payments. They took that to court and argued this made sense. So again, the scope is something that's constantly decided, debated, changed. Enforcement, the digital DMCA stands for Digital Millennial Copyright Act. You have statutory damages with copyrights. This is noteworthy because when you think about people taking, say, songs over the web, what's the damages? Suppose that Taylor Swift wanted to sue me because I like her music and I played, 500 copies of her music. Well, Spotify pays her 3 cents a song. I don't know if she's on Spotify, but that's what they pay people. So she could sue me for $15. Obviously, no one's going to do that. But they have statutory damages, which means she could get thousands of dollars damages, have me cover her legal fees. That's totally, an administrative decision. I'm sorry, a political decision that they decided to have serious damages associated with copyright violation. We don't have to do that. And if we didn't have that, if you just could collect actual damages, obviously copyright wouldn't mean very much, at least in a lot of cases, I should say. And trade policy, again, we've used our trade policy when they talk about free trade. I always find it ironic because our free trade agreements always focus on making intellectual property rules longer and stronger. So again, these are all very much policy choices. Things that have changed will change in the future. Okay, just to pick my favorite, I do a lot on prescription drugs, and I'll say some more on prescription drugs. But one of the big changes in patent copyright rules, or patent in the case of prescription drugs, was the passage of the Bayh-Dole Act in 1980. And essentially what the Bayh-Dole Act was, it facilitated getting patents on government-funded research. So prior to 1980, the status of government-funded research was ambiguous, and oftentimes private actors weren't able or felt they weren't able to lay claim to it. So you had plenty of government-funded research, primarily through the National Institutes of Health, but you often had private actors had difficulty claiming a patent on government-funded research. Basically, the Bayh-Dole Act regularized that process. So it made it much easier for drug companies, or in many cases, the individuals actually doing the research. So what you see when you have biotech companies, biotech startups, very often there are people working at NIH for 10, 15, 20 years. They have a great idea. They run to a venture capitalist. They go, give me $40 million. I'll develop this into a drug. Most of the time they don't, and it goes bankrupt. But if they do, then it's a big bonanza. They sell it to Pfizer, Merck, or one of the other big companies for $200 million, and they're rich for the rest of their life. But anyhow, that wasn't done before 1980, before the Bayh-Dole Act. My reason for showing this is it just shows the importance of, at least in the case of prescription drugs, the importance of patents. So it's common for people to say, oh, drugs are really expensive and they just keep growing in cost. Well, if you look at drug spending as a share of GDP, it actually was going nowhere till 1980. It was roughly 0.4% of GDP. Today, that'd be about 100 billion a year, thereabout. Then it went through the roof. Okay, it's about 2.2% of GDP now. It's about 600 billion a year. So this, again, I don't mean to say Bayh-Dole was the only thing that did that. There were other things that made it easier for companies to patent research, made it more valuable. And also, just to be clear, it did support a lot of research. So it's not as though we didn't get anything for this. We're paying a lot more for our prescription drugs. But on the other hand, we have developed a lot of new important drugs in many different areas. So I don't mean to say we just threw the money in the toilet, but we created this market that hadn't previously existed. So again, the point was, it was a policy choice. We could have done it otherwise. And we went from having something that was fairly inexpensive. In 1965, when we created Medicare, no one thought to put prescription drugs in Medicare because it wasn't that big a deal. It was like paying for aspirin. People could pay for aspirin, at least middle-income people could pay for aspirin. Today, you're talking about drugs that can cost you thousands, tens of thousands, even hundreds of thousands of dollars a year. And that's basically because of the patent monopolies and other protections that we've given to the drug and pharmaceutical industry. Okay, as far as the size of the patent copyright rents, again, I'm not going to say these are very rigorous. With prescription drugs, I could justify that by looking at generic drugs, looking at price of drugs in countries where drugs aren't protected. But roughly 80% of what we spend on drugs, I would say, is due to patent monopolies and related protections. Data exclusivity is the most important, but there's God knows how many other different types of exclusivity, intellectual property that we give to the drug industry. This is from a couple years back, 525 billion. It would be more today. I also, people point out to me, there's probably not a reason to sharply distinguish between prescription and non-prescription drugs, because you get many cases where something goes from being a prescription drug to a non-prescription drug just because the industry, the company that sells it decides they'd have a bigger market for a non-prescription drug. So they push their case to the FDA and it becomes a non. So there's not as clear a line there as, many people, myself included, were inclined to have. So anyhow, so just, again, the 80% figure for prescription drugs, there are any number of cases prescription drugs where they're selling for thousands of dollars per year for dosage here, tens of thousands. And you could find the same drug literally in India for $300, so it's not uncommon to see markups of well over 95, 99%. And there's actually research that shows that after generics have entered a market, drug prices fall by about 90 to 95%. So 80%, I think, is a very reasonable figure. Some of the others, computers and information processing, I put down 60% being due to IP. I think that's probably a conservative number. You just look at the, a cheap computer, $200-300 computer compared to a $1,500 computer. What's the difference? Does it have more material? Does it, it's just they could charge more because they put in better software, but the software costs them $0 to copy. So, that's basically all rents. Recorded music and video material, again, same story. I'm just trying to pick out the big ones. Again, I did investment categories, computers and peripheral equipment, same story. That, again, the software, that's that's the cost. You know, it's in most cases, they're just not very expensive. Medical equipment, you know, when you look at something like an MRI machine, other sort of advanced technology, these often sell for well over $1 million. There is some complication in manufacturing them. They won't cost, you know, $1,000. It might cost $20,000, $30,000, $40,000 to manufacture, but nowhere near the price that they're sold for. And again, we know that because you could find older versions of these technologies, and the difference between the newer machines and the older machines in terms of what it costs to physically manufacture it is in almost all cases very trivial. So they are, you know, they do involve complex manufacturing process. They have to be very precise, but the idea that there's some massive difference between the MRI that's being churned out in 2023 versus the one that was churned out in 2003, at least in terms of its physical composition, that's very little. So again, that's why, you know, I summed this to a bit shy of $1 trillion. Again, I think that's a very conservative estimate. It could easily be 50% more than that. It's obviously a crude estimate, but I really doubt you could come up with a story that it's more than 10 or 20% less than that. Okay, the third point, distribution. This again, it's a calculation I did, very simplistic, but you know, I think it gets to the point. I looked at the Forbes top 100. That this was from a few years back. I think it was 2017, maybe 2018. I did this, and I looked at the number of people on the Forbes 100 list whose wealth could be attributed to intellectual property, and which I call pure IP, and then mixed where there was ambiguity. So the examples of pure IP are obviously Bill Gates, Larry Ellison, who made his fortune in Oracle. There were a number of other people on the list who you could say, okay, they got their money from computers, from other technology that was clearly overwhelmingly intellectual property based. Media people, Bloomberg's on there as pure IP, because if we could all just copy Mike Bloomberg's business stuff and just pass it around freely and not send him anything, he wouldn't be one of the richest people in the world. So again, any one of these is somewhat arguable, but those were the people I listed as pure IP. Then you had mixed IP, where you had people where their fortunes probably in part due to having monopolies, have patent monopolies or copyright monopolies in some area, but not exclusively. So in that list, I had Mark Zuckerberg, I had Jeff Bezos, excuse me. And, you know, so I summed these, you know, and again, obviously it's a very, very simplistic, but just get ballpark numbers. So in the pure IP, you know, again, a few years back, the sum of their wealth came to 490 billion, which was 27% of the wealth of the Fortune 100. If you took the mixed IP, it was 299 billion. It was 16.5%. The total 43.5%. Point being, that's a very large share of the wealth of the richest people in the United States, you know, at least as ranked by Forbes a few years back. So when we're talking about inequality, I'd make the case intellectual property is a big part of that story, but goes even deeper than that. It's standard, again, the upward redistribution of income, wage income in particular, it's not really disputed at this point. It's common for people, economists in particular, to say it was due to technology. And this, again, is one of these things that is inclined to get me to pull out my hair or what I have left, pull it out, because it doesn't make sense. And just to make that point in a simple possible way, if we envision a world with no patents or copyrights, and I throw this out to people and go, oh, well, then no one would do any innovation, no one would do any, you go, okay, fine. Okay, but then there's not the inequality. So the point is that computer scientists, other people we think of as having technical skills, they can make lots of money because we have intellectual property rules that allow them to make lots of money. So the idea that it was somehow the technology, that's nonsense. It's the point is that we've created rules on technology that allow people with the skills, with certain skills, to get very rich, or at least much richer than people without those skills. So the idea is somehow that it's technology that has led to inequality, that really just doesn't make any sense. We could have different rules on technology, and the people who are doing very well in today's economy would be doing less well. Okay. The last point, and again, probably the most important point, there are alternative mechanisms. So again, the people say, well, okay, if you don't have patents, who would innovate? Who would develop new drugs? And point here is we have alternative mechanisms. My favorite is we could pay them direct public funding. And I don't know how many times I've had to literally yell at people they say, well, if they didn't get patents, who would innovate? And I go, we would pay them. And again, especially for economist type people, the idea that people should might work for money shouldn't be that alien a notion, because of course most of the people in the world do work for money. They don't work for patent monopolies. So direct public funding, well, National Institutes of Health, they spend over 50 billion a year funding biomedical research. And people who are on the other side of this from me always yell at me and go, well, that's all basic research, which isn't entirely true. They've developed a number of drugs. They often pay for clinical testing, so it's not entirely true. But that's by choice. That it's not as though there's something like, oh my God, they couldn't possibly usefully spend money on actually developing a drug. It's by design that they've made a decision that they're going to fund basic research and then let drug companies take it over and bring it through to fruition. So there's no inherent reason they couldn't do that, couldn't fund more, down the road research. And then plenty of examples. The most obvious one now is Moderna. They paid Moderna to develop the COVID vaccine. And incredibly, they then gave Moderna control over it. So they in effect paid them twice. But they paid them to do it, and Moderna did it very quickly, and it turned out to be a good vaccine and saved a lot of lives. So again, that's just one example. During a crisis, all sorts of things you could say, but the idea that somehow you couldn't do it is utterly absurd. The second one, a lot of people have proposed this, patent buyout fund. So the story here is that you'd have drug companies basically do research exactly as they do today. They go ahead and get patents exactly as they do today. And then you have a buyout fund that would buy out the patent and then put it in the public domain. And then anyone could produce it as a generic and be cheap. That does serve the purpose of getting drugs be cheap, be sold at their marginal cost. They could all be sold as generics. There are other issues. To my mind, direct public funding is a better route because you could have all open research. Not worth getting into that here, but just to say that this is an alternative mechanism. And again, to my mind, be hugely preferable to what we have now. The third one, research and development tax credits. You could give companies credits for doing innovation. Again, we already do that. We could make them larger. So research and development, I have to double check. I think it varies by area, but I think it typically has been around 20%. You can make it 40%, you can make it 50%. Again, it's a policy choice, and we could attach condition to it that, it has to be shared, that if it's publicly funded research, it has to be in the public domain. You could think of all sorts of conditions that you may want to attach to it. Point just being, again, it's an alternative way to finance research. The last one, a tax credit for creative work. This shouldn't sound alien because we already do it. So if I'm a really rich person, I want to support opera, I want to support my local symphony, I want to support the art museum. Well, the government pays me 40 cents on the dollar, I feel like contributing. We already do that. So we could expand that. We could make it a credit. At least that would be my preferred route. Say that every person has $200 to contribute to support creative work of their choice. And to determine what qualifies, well, people have to register with the IRS, kind of like what they do today. So shouldn't be a crazy notion. So again, you could argue whether that's better than what we have, but point is just we do have alternatives for both innovation and supporting creative work. Okay, so to just sum up, intellectual property rules, they lead to static inefficiencies and increased inequality. The static inefficiencies, again, I gave the numbers, but I can and should make the point when you think of something like prescription drugs, basically encourage companies to lie. Purdue Pharma made a lot of money till they got busted, telling doctors that the new generation of opioids wasn't addictive, even when they knew it was. Well, they had a really strong incentive to do that because they had a patent monopoly and they could sell it for a real high price. If they were selling it in a free market like paper cups and shovels, they wouldn't have had that incentive. They don't all become honest, but they have just much less incentive to become dishonest. Second point, again, it's policy. We can make IP shorter and weaker. It's not a question of 0-1. We could have as much or as little as we want. So we could make the patents and copyright shorter and weaker. There are alternatives. again, as I was pointing out in the last slide, shorter and weaker protections would reduce the demand for highly skilled individuals if we're bothered by inequality. That's a good way to go to try and reduce the amount of inequality we have in the economy. And just the last point, the idea that technology threatens to impoverish workers. There have been people, to my view, just saying crazy stuff about AI and what it's going to do, this and that. It's not going to be the technology that impoverishes workers. It's going to be our policy and technology that impoverishes workers. Hopefully we won't have those policies, but we can't blame the technology. It'll just be we managed it inappropriately. So that's my story. If there's anyone with questions, I'm happy to talk about it.
Thank you, Dean. If anybody in the room has questions, or if anybody online has questions, please type them in the chat.
Here we have a question.
This is a fascinating presentation, and as a cancer survivor, I certainly think that the pharmaceutical market is very distorted, but I also have a certain amount of confusion about this. So I have a fundamental patent in artificial intelligence, which never gave me a dime, because it is virtually impossible, unless you have a pile of money already, to sue Google and Microsoft for patent infringement. And the work was done in an attempt to build a better prosthetic hand. And so I never got the revenue from that patent that was hopefully going to support finishing the development of that. And I think a lot of artists are in a similar situation. You build you starve and you put out some work, and that revenue from that copyright's supposed to pay for the next one. If you don't ever get over that hump, there's a lot of creative work that just is never going to be out there. So I would suggest, though, that the inequality might be in partially in the enforcement side of this. Maybe you can comment on that a little bit as to, how do you enforce the rights you already have without a pile of money?
Yeah, no, it's a very good point. 2 points. First off, one, again, I totally recognize people who innovate should be compensated for their innovation. So that's the argument is, what's the best mechanism? So it's not that I don't think someone who's done important work developing new technologies, or you're also talking about artists, that they shouldn't be compensated. So what's the best mechanism? But the point about enforcement, that's an incredibly important point, because you have, well, 2 things. One, there's a whole industry of patent trolls. You probably heard about this. So people who file suits, that you have very skilled patent lawyers that file a suit that might be a totally bogus suit, but they feel they could botch up whoever's innovation. And that could even happen to big companies. There was a famous one with what was it, the first like smartphone, BlackBerry, that there was a patent suit filed that BlackBerry was quite certain would lose, but they managed to get an injunction. So what that would have meant, BlackBerry was marketing itself as a high-end device for business people who needed to be in communication. The injunction would have said, okay, you're offline for, could be a day, could be a week, could be a month. They couldn't have that. So they ended up paying hundreds of millions of dollars to get them to go away. So that's an incredible problem that, you have, basically a huge amount of money essentially on the table that people with skilled lawyers and expensive lawyers could benefit from, but it serves no economic purpose. For a long time, every time Samsung or Apple came out with a new phone, they'd go to court, the other one would go to court immediately and file all these suits. And that went on for, 2 years, 3 years, and eventually they did a ceasefire. So, it's incredibly wasteful. So, to my view, I don't think there's a good solution for that when there's so much money on the table. So my view is we need a different mechanism. But again, that's part of the point as to why the patent copyright system is so inefficient, that you end up getting huge sums of money being basically just totally wasted. There's nothing productive about a patent suit between Apple and Samsung. Tell them to go and figure out how to build a better phone. Don't go fighting each other over some frivolous patent claim. But if the money's in the latter, that's what they're going to do.
Any other question, comment?
We have two people that have joined us online. If you guys have any questions, you can type them in chat or Q&A.
Here we have another question.
Okay,
So
that
a
will
bit,
be our last one because we are just
Okay. Oh, I just had a follow-up that I'd ask you to comment. Are you aware that if you have enough money and somebody brings an infringement suit against you, that you can actually get a patent issuance revoked in some cases? And perhaps you could comment on that.
Yeah, there was, what was it? The American Invents Act that, I'm not positive this is what you're talking about, but that was, I think, in 2011, and creates a process, a non-judicial process. So it's not in the regular court legal system where you have panels where you can claim that a patent was inappropriately filed. Again, to my view, I think that's a good thing because you have a lot of patents that clearly are bogus. There's any number. The one I always cite is that someone literally patented a peanut butter and jelly sandwich. I think it was 1998. I'm not kidding you. You could look it up, patent on peanut butter. I don't have the exact number here, but the US has a notoriously lax patent office. So you have a lot of patents that have no business having been issued. So making it easier for them to get off the books, I think, is a good thing. But obviously that could be abused, you know. So again, I just think the patent system is a horrible way to finance research in general, particularly with pharmaceuticals, because again, it just drives me nuts, the idea that, you know, when someone's a cancer patient and they need a drug, you know, that the company is charging $50,000, they charge over $100,000 for some of the new cancer drugs. That's how we're going to pay for research that might have been done 10, 15, 20 years ago. That's close to nuts. So I think, again, particularly with prescription drugs, patents are just an incredibly pernicious way to finance the research. I think it's more reasonable elsewhere, but even in most other cases, I think it would make much more sense to have shorter patent periods and rely much more on publicly funded research and open research. So, you know, one of the things I've written about was instead of the patent length being 20 years, you could say, okay, it's going to be 4 years, but if you agree to a 4-year patent, then you have access to all this other research. So in effect, you partially open research that you could agree to a 4-year patent. After that, it's open, or you could have a 20-year patent and it's not open, but then you don't have access to the other research. So I think we just should make patents much, much less valuable and encourage people instead to focus on, you know, the research, basically, the innovation.
Thank you, Dean. Thank you for a wonderful presentation, and thank you everybody for questions. We are going to end the panel. Thank you so much. Bye-bye.
Thanks. Bye, everyone.